trusts can be very helpful and useful for people who are receiving government benefits or are receiving health insurance, for example, through the ACA or through the MAGI program. There are restrictions on eligibility for those programs. So how does a trust fit into this situation? Well, anytime you hear the term trust, you should be asking more questions. A person who receives a personal injury settlement from a car accident, for example, if they want to receive government benefits, and those are going to be needs-based government benefits, meaning their eligibility is going to be tested by their resources, for example, that person would create, if they're under age 65, what's called a D4A trust. And that way they get the benefit of the money that's in the trust and continue eligibility. If somebody is over 65, then their option for such a trust is called a D4C trust. So those are what we call first-party trusts. If instead of you trying to maintain eligibility for yourself with your money, instead you're concerned about helping somebody else, that would be called a third party. Even if they're your child, it's still a third party. Your spouse, still a third party. So if you're looking at helping a third party keep their eligibility for certain government benefits, yet still have money, there are ways that you can do that. You create, either during your lifetime or through your will on your death, what is called a supplemental needs trust. Sometimes it's called a special needs trust. Any assets that are within that type of trust are not counted by the government when measuring eligibility for government benefit programs. The key thing about this type of trust, the supplemental needs trust, is that it must be discretionary. What that means is you do not want to mandate that X amount of money each month will pay out. If you are going to do that, you're going to run into problems. The reason that you're going to run into problems, at least in the state of Washington, is that any kind of provision that mandates payout, even of a certain X amount of money per month, could cause the entirety of the trust and all of its assets to be deemed to be owned and available to that special needs beneficiary, that person who is on the government benefits. Now, other states might have different rules, but in the state of Washington, it is by far the best practice to not mandate payout of a certain amount of money per month to anybody who is on any government benefits programs. So instead, in Washington state, we would set up the trust to be what we call a discretionary trust. What that means is the trustee is still has the opportunity to provide money to the beneficiary, but will do so in a way that will not interfere with those benefits that beneficiary is receiving from the government. This area of government benefits and trust administration is fraught with all sorts of rules and complications. I would recommend that if you are in the situation contemplating needing to create such a trust for a beneficiary, or if you're even administering a trust like that right now, see an attorney who will help you. There's also a really good handbook that's published by the Special Needs Alliance to help you if you are a trustee on how to administer the trust. But definitely for setting it up, seek out the services of an elder law attorney.